And I just want to welcome Jay Warona. Hi, Jay. How are you? I will unmute you if you cannot be unmuted on your own. Let me see. Let me get down there. There you are. Unmute. Okay.
Thank you.
And let's see if Beth Harris.
It's good to be unmuted.
It's freeing, very liberating, right, Jay?
There you go. There you go.
And I know that Beth Harris will be joining us shortly. I am monitoring our participant waiting room. For those of you who just joined us, we are transitioning into our our distance learning Q&A, legal Q&A with Jay Warona and Beth Harris. Beth will be joining us shortly if she isn't here already. And I know that a lot of legal questions are on your mind. Here's Beth now. She's coming in. Let me make sure she's also unmuted. Welcome, Beth. How are you? I'm just unmuting you. Hold on one second. There you are. Hi, Beth. Welcome.
How are you all?
Introduce yourselves momentarily. I just wanted to welcome everybody. This is part of our PNW BOCES PL on the Go. My name is Jackie Levine. I'm the coordinator of school leadership and marketing services for PNW BOCES. We are delighted to be able to offer this session as part of our professional learning on the go on the legal Q&As that you could use right now in this weird and new time. I'm sure that Beth and Jay have a lot of great information for us. So I'm going to turn it over to them to either share their screens or just be the main speakers for the time. If they have nothing to share, that's fine. Questions could be popped right into the chat. I'm going to moderate the chat. That way we don't all call out at once. If you have a specific question or need to embellish a little bit, please use the raise hand feature in our managing participants section. I'm happy to call on folks and unmute your mic for you. We will remain muted so that there are no background noises and so that folks can clearly hear each other and that Jay and Beth can clearly hear the questions being asked. I had received some questions in advance from a couple of our leaders, so I gave those in advance to Beth so she has some talking points to start with. And I'm sure Jay will also be chiming in with a few things, maybe some updates of things that are changing as of today. So I'm going to turn it over to both of you. Thank you again for being here. Thank you all for being part of PL on the Go. Again, I'm Jackie Levine. I'm going to put my email address and my Twitter handle in the chat. I encourage you to do the same. Would love to follow you on Twitter, but if you don't have anything to go into the chat right away, that's okay. I'm sure there will be parts of the presentation where we will pause and ask for additional questions. Just plop those questions in the chat or raise your hands and we can call on you. Okay, thanks so much, everyone. Go ahead, Beth and Jay.
Hi, Jackie. Let me thank everyone initially for coming. I'm so honored to be doing this with all of you. I feel very appreciative that we have the technology that allows us to come together in this space. I know that we are all building planes in the air and that things have been evolving and changing faster than one could ever really have imagined, major events and things happening. So with that said, what I have seen in the field is the spirit of cooperation and understanding, leaning on one another and collaborating rather than getting at one another. And so every day that I encounter that among colleagues, I feel a sense of gratitude. And so I hope in that spirit we will come together with our questions today and we'll answer the things that we can. I know, having spoken with Jay a number of times over the last several weeks, we don't know a lot until we do, and then when we do, we have to figure out what we exactly know and then take it from there. So we are at the point in time where it's April 2nd at 2 o'clock in the afternoon, and we know what we know as of this minute, and we have some open questions, but I think we are going to settle down about certain issues while we still have many very big unanswered issues to still address. I will tell you, I have technical difficulties on my end because my work server computer will not accept Zoom, so I have to be outside of our VPN connection in doing this webinar, and for that reason I can't have a screen that lets me keep those questions that were emailed to me by Jackie up in front of me. So Jackie, if you wouldn't mind prompting us with the questions that you received, that would be really helpful to me. I just can't see them simultaneously with being on the Zoom platform.
Absolutely, I can do that. And hold on one second, I'll pull up the first one. Good friend and principal sent to me just yesterday. Okay. Hmm. One moment, technical difficulties on my end, but that's okay. I think one of the things that you could maybe address first, Beth, would be about attendance, student attendance, and even teacher absences. What guidance can you give us about that?
Right. So, the state aid issue that has taken so much of our time in the last 2 weeks leaves open the question of how we can effectively monitor student attendance in the virtual distance learning environment. And I know school districts everywhere are struggling with that, and that we don't have firm definitive answers and guidance yet from the New York State Education Department. You would agree with that, would you not, Jay?
Yeah, well, I mean, it's been in certain contexts, like, the spring break and
Right.
religious holidays, but I'm not even sure, Jackie, I understand the question per se. When you say about absences, what about absences are you actually, what is the individual looking for?
What I understood the question, let me say what I understood, because I understood it a little bit differently than Jerry. I understood it to be asking the way in which teachers on a period by period basis or on a daily basis in the elementary school would be taking attendance. How are we doing that in a virtual space, because that information is relevant to the calculation of state aid.
Okay, I see. Yeah, I don't think that we have a lot of answers on that. And I know that this week, the folks at the State Education Department are trying to figure out how is it at the end of our time this year, we're going to credential anyone, whether they be a graduating senior or kids in elementary school. So all of that is part of this, accounting for their attendance, but it even gets broader than that. How do you account for whatever learning they have, secured?
Right.
So yeah.
I've given a little bit of thought to the practicalities of it and some suggestions I can offer until we do have definitive guidance. To the extent that every school district is doing distance learning slightly differently, depending on the method by which you are rolling it out, there are ways in which teachers can monitor student participation, even if it's not contemporaneous virtual streaming, which obviously lets you know who is actually there by virtue of being able to see them visually or have them log in telephonically. In other ways where there are pre-recorded lessons, there may be assignment submissions. So I think it is going to be critical, regardless of what we ultimately hear will be, the minimum to be satisfactory in terms of demonstrating the attendance necessary to do the state aid calculation. To have certain data, the data that is practical for the manner in which you're delivering that instruction. So it could be as simple as having a couple of questions and answers to be submitted by students at the conclusion of a lesson, so that teachers can verify that they in fact participated in that lesson, even if it's a pre-recorded one. Or obviously the virtual meeting space, we don't necessarily want the third-party vendor to be maintaining the data on who signed in and out, but having teachers or teachers' aides or whomever is charged with attendance in that way, recording themselves the participants.
The only thing I could add to that, Beth, is in my discussions with folks at the Governor of Education herself, I mean, whatever accounting they have to secure, they just want it to be reasonable. They're not looking to be in a, kind of a school marm, mode where they're going to cut anybody off of state aid. That's really not their intention. So I think as long as we come up with a process that is reasonably, appropriate, will be just fine. Particularly since they haven't really, given us the rules.
Right.
It would be very difficult to hold us responsible for rules that have not been, provided.
Right. And, I've suggested to a couple of my school district clients, helping get IT involved, like so that read receipts are collected when there's a push out of information or a push in of the receipt of information from students, that we're recording that data and then being able to use it later, which, as Jay suggested, can be, not so onerous, but enable us to have something for accountability, purposes for numbers. I think that works well.
Thank you both. So I have another couple of very interesting questions. Here's the first one. Many folks are looking to use platforms like Zoom to interact with students in their homes. As mandated reporters, if we observe a student being hit or there is a need to call CPS, a teacher's anonymity is compromised. What legal protections do we have in these virtual environments when it comes to mandated reporting?
I think that the virtual anonymity issue is really actually almost the same as it presents itself in school. While I understand the concern and the feeling that there is less variety of people that could have done the reporting itself, it hasn't changed the social service law mandate found in the 400 sections of New York State social service law that the identity of mandated reporters be made confidential, both for child abuse in an educational setting. Ultimately, those records are kept confidentially, as well as in the domestic setting. So here you're going to have the intersection of the domestic setting and the educational setting when you create the virtual learning environment. You have the educational setting, and as much as you have educators in it, it's hard to imagine how you could abuse a child in that forum, but it is conceivable. I've had a couple of cases throughout the years, not to give you war stories, but where a teacher has said something so egregious and harmful to a student that it rises to the level of a psychological abuse that gets reported as child abuse in an educational setting. One particular event comes to mind. But then you also have what I think you're speaking to, which is the observation of perhaps something abusive in the home happening during the virtual lesson. So I think the reporting procedures remain unchanged. I think the obligations of mandated reporters, which expanded this year to include people like ABA providers, related therapy providers are now on the list of mandated reporters. All of those folks should be following the reporting procedures as they would as if they were in a school building.
Thank you. Anything to add, Jay?
No, I think that's pretty much it. I mean, I think it is such a strange world that we live in right now, right? That we're trying to do distance learning and people are thinking about these things, which are scary things. But I totally agree with Beth that despite the technology, our obligation doesn't change at all.
Well, thank you, because our next questions are geared towards certain obligations. Related service providers are concerned with what occurs virtually during a session being used against them. What advice can I give them to ease their concerns?
I guess I would ask for clarification on what it means when they say being used against them. By whom? By the employer? By the students?
Hi, I can talk if you want. It was my question.
Okay.
Basically, hello. They're worried about parents who may go to like the Office of Professions and say that maybe they're not doing something correctly, or so we have some parents who are educators, and they're concerned that they will judge their methods and make reports about them.
So I've been working with the special education administrators that I work with and our clients to develop a consent form. And we can ask those parents that are in the disciplines that the New York State telepractice guidance tells us require consent prior to telepathic services. And those are things like ABA, the mental health professions. OT isn't answered. PT and speech are said not to need the consent, but nonetheless, I think it's advisable. I like it for the following reasons. One, the SED guidance on the Family Educational Rights and Privacy Act and distance learning strongly suggests the transparency with students at the end of the guidance document to let everyone be on the same page about our expectations for those learning environments, specifically that we would expect parents to create a semi-private space where the children are receiving the therapy, if necessary, with the parents' involvement for a high-needs student, but otherwise so that other children would not be privy to it, other adults would not be privy to it, so that the student's record rights are protected in that way. But also we warn parents that it's our expectation in terms of the therapy session that it's not going to be recorded, that they would be observing what they're observing with the limitations they're observing it, and that it is understood by both SED as well as the U.S. Department of Education that in terms of the delivery of those services, they're not going to match virtually identically to what we would see in a classroom space or in a related service space, and that we are, if you want to use the word improvising to the extent that we can, that's appropriate to meet the students' needs within the parameters of the professional guidelines, which are, you know, available. And I think it's understandable that service providers feel a certain sense of nervousness or anxiety around that. But, you know, I think as school districts and as BOCES goes to confront those issues with staff, understandably feeling that way, I think what we need to reinforce is that there is defense and indemnification for any claims that are brought against employees or contractors in the school district performing those services, and that we are prepared to defend their practices provided that they're within the parameters of what is reasonable under the guidelines.
Thanks. So I'm glad to hear that you're coming up with a consent form, because I work with Mike Lambert, so that was one of my questions. Thank you.
I can share it, certainly.
So Joe, that answers your second question, or did you want to ask your second question as well?
I have to go back and look at it, sorry. I'm
Okay.
getting
I'll
other
wait.
questions.
I'll shoot you an email when we're done.
Okay.
All right, I appreciate that. Thank you.
Virtual related services may not be appropriate for all students. If we are providing to some and not others, are we still providing equitable experiences as guidance is stating we should?
So in that regard, what I've shared with the people I've spoken to about this is I think you want to have an objectively reasonable rationale for what can be delivered and what can't be delivered. And it shouldn't be that we don't have, you know, the money to spend to get the technology in place for certain students. That would not be a good reason, but rather, for instance, something that really truly requires physical contact between the provider and the student themselves that can't feasibly be done absent those types of direct contact or observation. And in that way, I think what's going to be most critical as we go down the road and we see challenges to this when the dust settles is having a record, even if it's just in provider notes informally or in IEP notes, wherever you want to keep it, about how you analyze this and why the decisions were reached the way they were. SED has certainly encouraged our collaboration with parents around those issues. Again, the transparency, the dialogue, helping, I always believe, helping parents understand why as educational experts you feel one way versus another about a service or a service, you know, a service volume, a service delivery method is helpful. You're not going to convince everyone. You can please some of the people some of the time, but not all of the people all of the time. But the communication and the open, you know, explanations to increase understanding, I think go a long way. And then you have the parents that are going to see it their way no matter what, and that's where the record keeping comes in, because we know contentious parents will use the resources if they have them to bring the hearings, and we'll be in a position of having later to explain and defend our rationale. And we want to be sure that we're not in a position where we can't show that students with disabilities were provided equal access to the educational programs of the district, and rather in the instances where we didn't deliver to them, we didn't deliver because of the feasibility issues rather than a choice that was made. And there are practical choices that have to be made just based on provider availability. I mean, there are illness issues that are presenting themselves with the providers, with the students, with the families. So there are factors that can impede the ability to deliver to particular disabled students for reasons other than the distance learning technology.
Thank you, Beth.
Thanks.
And I'm sorry, Jay, did you want to add something?
Sure. I assume everybody's seen the March 27th, last Friday's memo from the State Education Department on special education matters. And everything Beth said is pretty much spelled out in there. I mean, there are provisions throughout there in which in almost every context, and I just want to find this one part, they say New York State Education Department will be as flexible as federal and state law and regulation allow, and will continue to, they just talk about flexibility, understanding that we may not be able to meet all of the obligations that we have for students' IEPs. And if that happens, then we'll be talking compensatory education services, as opposed to, playing gotcha with a school district that, to no fault of its own, simply does not have the ability to provide certain special education services in that modality. So, so the bad news is, we may have to go beyond the year. The good news is we'll be able to provide the services, and the further good news is the state education department, as well as a federal guidance document that came out last week also, is indicating that we're all just doing our best. And that is the lens upon which they're going to look at this.
Yeah, and as Jay mentioned, the compensatory educational services piece of this, I think that it helps to think in this way about it. What isn't feasible to be done now will need to be thought about later, and being transparent with parents in that way also, I think, helps, letting them know, as far as you haven't been able to do it right now for whatever the practical or technological reason is, you are giving consideration right now already to how you're going to deliver that. You want to assure them that at the appropriate time, once you know the magnitude of and duration of this, that you'll develop a plan for the rollout of those compensatory ed services. Keeping in mind for your own purposes that there is an abundance of case law, although there may be some more guidance, I suspect, in this area, given the pandemic implications. The case law that exists currently on compensatory education makes clear that when you go to make up services later, it isn't necessarily going to be a one-for-one. It's going to be an individualized analysis of whether and how the deprivation of services over the duration of time has actually impacted the student from a regression standpoint, and then how best to approach pedagogically the makeup of those services. And it does not necessarily equate to a one-for-one, because the intensity of the services when you make them up will be different in all likelihood. So a student who misses, for example, a group session of speech and language services, who later has it made up, may not have it made up in the same size group. It may be a much smaller group. It may be that the one-on-one delivery, for example, of reading instruction is a greater intensity, and so then you're recommending something that is aimed at the deficits that got created by the absence of service over the duration, and a plan for that.
Thank you, Beth. To stay on the special education question, we had a question from Angela regarding CSE meetings. Is there a preferred platform we should be using solely for CSE meetings so that we can best protect students' information virtually? And can a parent request for the meeting to be recorded?
Okay, so I would say about that, I have experienced several of the platforms, having participated in a couple of CSE meetings at this point virtually. I know that, part of the consideration is going to need to be around the technology available to parents, and depending on disparities among access to technology, Wi-Fi, the use of laptops versus only the ability to call in. Some school districts have been able to roll out technology to families that didn't have it by virtue of a computer or software loan that's authorized specifically by sections 752 and 753 of the education law. There's the opportunity to loan those things that way, but where you're not doing that and you have a split among who can participate in what modality, I've seen the use of platforms like Google Meet, which I had the experience earlier this week. I wasn't even aware that you could have a call into it as well as a login to it. I would say the overriding legal concern is that whatever platform you're using be compliant with FERPA and Education Law 2D and the PPRA. BOCES has been really helpful in terms of the BOCES 1 consortium, or RIC, producing a document that has all of the state contracts for modalities that are compliant with FERPA and Education Law 2D. I know I circulated that to our clients, and I shared it with Jackie because I think it's really, really important right now that, to the extent that you need these things quickly, that you have the resources that are available. If you don't already have contracts locally that are compliant, that you can reach out and use those that aren't. And I would say the one thing I've been dissuading people about is allowing the rogue use of whatever technology folks have on their home computers that is not part of your system. I know there's been some of that going on a triage basis, trying to keep in contact And I understand it. I'm not, living in an ivory tower and scolding anyone for doing it, but I think it's really important to streamline so that we have the compliance and we don't create liability and unnecessary student data privacy infringement issues that way.
Thank you, Beth. Jay, anything to add?
I don't really know too much about the platforms, but the only thing I would add is that, just make sure that whatever platforms are used, they're going to be in compliance with the obligations under Section 2D of the education law with respect to data privacy protections, meaning that they're encrypted and all that stuff. And I'm sure that the district will know which ones those are. But in terms of which ones work best for special ed, I defer to my great friend Beth. I don't know which ones are the best ones.
Yeah, I like anyone that will allow people to both participate through video conferencing as well as call in for the practical reason I mentioned. Not everyone is set up for the video conferencing. It may cause parents anxiety. They may not want to reveal that they don't have the economic means to participate through a computer. That may be embarrassing to them. So giving them the option, I love that. But otherwise, I would say obviously the video conferencing creates a more meaningful participation in as much as you can see folks and interact with folks and share documents. But there are other ways to address those practical concerns by ensuring that you send out emails in advance that attach any relevant records that you're going to be reviewing at those meetings so that they can be in front of everyone. If parents don't have the ability to receive them by email, I know that that's a little bit unusual still, but you can, get ahead of that issue by having them sent through the mail, as challenging as that is right now. That's really the last option you're left with.
Thank you, Beth. Thank you, Jay. I have a next question. The questions are coming in fast and furious. If we have received a FERPA request for copies of all educational records during this time of closure, how are you directing districts to handle this in the event that we are closed for an extended period that goes beyond the 45 days?
I think that FERPA, fortunately, based on the U.S. Supreme Court case Gonzaga, does not carry with it monetary damages, so everyone can take a deep breath that a FERPA violation is not going to equate to financial liability. I think that to the extent that it is unfeasible to gather records, FERPA provides a right of access to records. It does not actually entitle a copy of those records, although there are cases, involving partial hearings where we know for sure we're supposed to be creating copies for access. So the access to records can be accomplished depending on the record electronically. Sometimes where it can't be accomplished electronically and you're worried about the ability to feasibly make copies because that is your policy and that's what you have committed to doing, I think that you're going to do it in the practical time frame that you can do it in, absent being unreasonable. I don't think there's going to be any liability associated with that.
That's great. Thank you so much, Beth. Our next question is a little bit about a teacher's right to privacy. So teachers might have expressed concern about, if there's a certain book on their table or something that is viewable during video conferencing, what might be their right to that? So the full question is, while working from homes and connecting with students and parents in their homes, what is the teacher's or student's right to privacy? We would not normally invite 20 to 25 students into our homes when we were not at school, but we are now asking teachers and administrators to do just that. So if you had, say, an aggressive parent or something who observed something and wanted to, maybe observed a book by Marx on a teacher's table, and the parent wanted to label the teacher a Marxist because of seeing this book without proper context, what are the teachers and students' rights to privacy?
Yeah, so what I would say about that is that can be dealt with proactively. I know that certain school districts are rolling out local rules, if you will, for staff relating to the expectations, and parents and students as well, relating to the expectations for how virtual learning spaces will be kept in terms of the privacy issues we've already discussed, but also in terms of their learning environment, the same way we would not allow staff to post political messages on the walls of the classroom, we would also expect that those messages would not be posted on the walls of a virtual classroom. Not that we're expecting to take over any individual employee's home in that way, but all we're simply saying in rules is you choose the space where you believe you don't have issues of privacy that would be infringed upon, and you can deal with it yourself that way. And we would ask the same of students. Don't put teachers in a position where they're forced to watch, you know, your younger brother in his underwear coming out of the bathroom. That's no good either.
Mhm. Thank you. What are our rights as far as copyright infringement in a virtual world? Are we personally liable when reading text to students over a virtual medium? I read the daily message on YouTube and send it to the parents for the children to start their day. If I read a text over the internet, am I covered as a school administrator or teacher?
Okay, so the analysis on that would be the test of acceptable or fair use, excuse me, under case law relative to the portion of the literature or music or whatever you're using in terms of instruction as relates to the whole and the licensure that's required. So there are certain, you know, the educational use exception that allows you to use certain things still depends upon your ownership of the volume to begin with. And if you're going to be distributing it to an entire class, there's an individual case-by-case analysis that needs to go on about the portion you're using versus its relative significance to the whole. So I can't answer that on a global way, in a global way, but I can say to you the educator who submitted that question is right to be tuned into it and sensitive to it, and would be well advised to consult with legal counsel about questions in that regard.
So Jackie, let me just add one really quick thing, because there's nothing that Beth ever says that I disagree with.
Oh.
No, I just want to add two things. Number one, I do think that, you know, when this world becomes more perfect and we, God be willing, get through this whole crisis, you know, I think this whole fair use thing is an appropriate in-service activity for schools to have with their staff anyway, right? Because this could happen in the classroom also. So I think to the extent to which whoever was asking that question is confused about it, maybe the confusion is because we haven't done the best job as a district or a BOCES or whatever to provide a clear understanding of what's acceptable. So I would really, I think that that's first and foremost, and then making sure the policies of the district are consistent with all that, everybody understands it. So that gets us to a better place. I also wanted to just comment on that last question about the First Amendment. I guess what I would say to any staff member or administrator is, even if there was a lawsuit and the person said, I have a First Amendment right to have, you know, a book of Karl Marx on my table, even if they were to be able to prevail in that, you know, there's another thing we focus on, which is winning in the court of public opinion, right? So if that same parent goes to the newspapers or to the, you know, to the TV media and starts fighting that battle about how this teacher was trying to, you know, proselytize children religiously or politically or whatever, there's no winning that. So I guess I would just simply say that people really need to use some good common sense. It's not even a question of constitutional rights. It's just intelligence. I mean, go into a room with nothing and you know, and broadcast from there. Don't place yourself in that kind of a position, because even if legally you were to be successful, you may not be in the court of public opinion. So I just wanted to add that.
Thank you. Thanks, Jay. I have another question about this, a bit close to this. How can the school enforce student discipline over a medium like Zoom? If a teacher observes a student vaping during a live session, does that student fall under school rules, even though they are at home or another setting other than school grounds?
I think you can safely say yes to that in the following way. One, I would take on the commissioner's appeal that challenged student discipline, saying that, you know, he was in his home and it's off campus, so it's allowable, because one, there's still a nexus. That conduct is then going to create the impression that we endorse in some way the allowability of a student who's vaping while during instruction, even if it's prohibited on school grounds. And the student is technically not on school grounds. It is creating a disruption to the instruction. It is also probably off-campus misconduct bearing a nexus to protecting the safety of other students who might come to believe that that's okay, as well as disrupting the educational instruction happening in the virtual learning environment. If anyone had thought we would be where we are, we certainly would have created a clear sentence or two extra in the codes of conduct this year that explained in virtual learning environments we intend to enforce the code of conduct disciplinary rules and procedures in the identical way we would enforce them if you were on school grounds. No one knew this was going to happen, so it doesn't appear there in any code of conduct that I'm aware of. And the only, I would say, if you want to be legal textbook concern I could come up with if I were on the other side of that is the notice of the rules to be enforced under the 14th Amendment, the due process concern that would exist absent clear language in the code of conduct to that effect. But I think that we would get around that from a legal argument standpoint, saying that we gave reasonable notice under the line of cases that say that's what our due process charge is. It was reasonable to understand that if the learning environment changed to a virtual platform, that we intended to enforce the rules all the same. And also that even if that doesn't cover us, we have provision in most codes of conduct that I know of, and every client we represent, that would cover off campus misconduct where there's a nexus to the school environment or the disruption of instruction that would carry over from the off-campus site into the virtual classroom.
Yeah, I would just add, it's not really adding, I'm just a couple more things. I would focus mostly on this disruptive thing because, you know, the smart ass kid would be able to say, well, I wasn't vaping. What I was doing was making believe I was vaping. And of course you can't prove it like you could at school if you catch the kid, you know, engaging in that activity. But what you could do, exactly as Beth said, is let's say this kid is engaging in this activity that you don't really know is vaping, but you think he is or she is. And you can look at the screen like we're looking at each other right now and seeing that all of the kids are just looking at that other kid and not listening to what the teacher is saying. And then you're focusing on the fact that this just disrupted the class. My point is, you know, you could potentially lose the battle of being able to prove it was actually vaping, right? Because you're not there. But you can't necessarily, you shouldn't lose the battle if you do all of the things Beth focused on before with respect to, you know, the disruptive factor.
Great. Thank you both.
And many codes, lastly, many codes of conduct will also enable you to go under language if it's there that talks about either, you know, for example, marijuana or a substance that is purported to be marijuana. So the student who's mocking you by saying it wasn't really vaping, I was just pretending, you know, there are provisions of that portion that will say a vaping device or one that is held out to be such. So we don't have to get into its actual usefulness in that way.
Right.
That's helpful. Thank you.
Yeah.
So shifting now to grading and testing and things of that nature, what are the guidelines around grades versus pass-fail and the implications of choosing one or the other?
So every school district has a grading policy. It's a board policy, so it's going to be a determination, you know, made by the Board of Education, presumably on recommendation of administration and superintendent of schools. To the extent that they're going to want to be changes to that policy based upon what's happened that was unforeseen, that's likely to be something that is either already happening in the works or that will happen as the spring rolls out and we know more about the duration of this quarantine period and how long schools will remain closed. The idea that you could shift to pass-fail grades would, you know, be something that I think a lot of school districts are going to be giving consideration to. Right now, there is not yet that I know of any guidance from SCD on this, although I would like to believe that there will be. I don't know when that will be exactly. And I don't know, Jay, if you want to share anything else on that.
Yeah, I assume the question is, you know, you didn't use the last three words, like, you know, in relationship to COVID-19. I assume that that's what this question, it's not just about grading, right? Yeah, so we're waiting, as Beth just said, this week, I know I conducted a webinar for like 1,300 people this past Saturday, and I had the commissioner as my guest, as well as Dan Fuller, who's the governor's Secretary of Education. And what the commissioner said was that this week they were going to be looking at trying to figure out, you know, how we, you know, quantify what grades are going to be this year. I mean, these are unprecedented times. And then this coming Monday and Tuesday, a week from, well, just the next Monday and Tuesday, the Board of Regents will be meeting, and that's when they should be making a decision about that exactly. And so we're premature with this question, not because it's not an important one, but we're about to get an answer, you know, in less than a week as to how this is going to play out for this year. And I know that they don't want to place students in a position, look at our seniors who just need these credits so that they can go to college next year, right? Look at, you know, look at kids who are not going to college but need the high school diploma. So they have to figure this out, and I'm sure they will, but I honestly don't know exactly what that's going to be at this point in time.
Thank you for sharing that. Someone might be in. Oh, okay. Looks like those next two questions I had then are pretty much summed up by your answers just now. We had questions about transcripts and whether or not districts can change the way they calculate them, and Regents exams, what happens if we don't take them. So I guess we can wait for further guidance on that.
Yeah, I mean, the only thing I would just tell you, Jackie, is the commissioner during my webinar on Saturday specifically answered the question of Regents by saying that was going to be considered this week. The reason there wouldn't be an announcement is because whatever their recommendation is, they being the staff at SED, the Board of Regents have to officially vote on that next week. So I think on Monday or Tuesday of next week, there will be an answer on the Regents.
Fantastic. I'm sure that's music to many people's ears. Our next question is, what is the legal balance between administration being allowed or having access to assignments shared into a teacher's digital classroom, assuming that it would not be used for observation purposes, to be in tune with the accomplishments and delivery of instruction during this time of distance learning? And Lou, do you want to expand on that? Do you want me to unmute your mic so you can expand on it?
There you go.
Oh, there you go.
It just, it seems, hi guys, it seems like conflict between, you know, sometimes administrators and teachers, you know, administrators, just because we're going through this whole thing and just wanting to know from time to time what's going on in the classrooms, how it's being delivered. In many cases, really in advance of any potential parental or district questions that we may get, where I could understand the teacher's concern about letting the administrators in, not necessarily to use for observation, but use in a judgment way, which, you know, obviously depending on administrators, many of us, that's not what we want to do. We want to support our educators, especially during this tough time, because they're doing amazing things. But it just allows us to deal with boards of education or parental issues, or even from a BOCES standpoint, district issues, to say, hey, you know, look at the great things that we are doing and examples of it. So I understand the balance. I understand it's like new territory for everyone. But what are the rights of the teacher administration wise? And I know it's usually it's a relationship thing, but it's also it's a concern going down the line. Thanks.
I think depending on the use, depending on the district, depending on collective bargaining provisions, there may be restrictions on some of what you're describing that can either be negotiated or not. There will be certain things that are management rights to do. So I know you're asking a really important question that's probably, you know, in the minds of lots of people, but I don't feel comfortable answering it in a global sense, because I don't think it can be without the specifics of what you're looking to do in a particular situation and what you're looking to do with the information you collect.
Well, let me see if I can add this though. I agree with Beth. You know, we can't answer in a particular situation, but I can tell you that Beth answered a question before by indicating, hey, you know, moving forward, we'll make sure we have policies that clearly are written in a certain way. And I know that as we move forward with virtual learning, and let's be honest, I mean, with this horrific virus, we've almost been promised that it may repeat itself. And so if we have to go back to this whole modality, I don't think there's a school district in the world that's gonna not wanna be able to get inside a virtual classroom for purpose of doing just as we would do in our school buildings. If we hear someone screaming in the classroom, nobody's going to say an administrator can't go in there to see what the heck is going on. And if an educator is being emotionally abusive or whatever, I mean, of course we'd want to know that. But Beth is 100% right. Sorry, that is my dog, and I apologize. Hold on. so at any rate, but if we try to maintain some type of disciplinary posture, as appropriate as it may be, it is very evident that the teachers union might be able to say, and will be able to say, that is not something that you have a right to do. So all I would say, the only thing I'm changing to Beth's answer is, I think moving forward, we need to make sure that we have as management rights those protections, because our classrooms are going to be expanded in this way in the future. And we're not in an Orwellian type of territory anymore. This is our present reality, and it will be our future reality. So that's the only thing I want to add, that I think we're going to need to make sure that we protect ourselves in the future in that regard. But Beth is right, to the extent to which we try to be enforcers, even if that's not our intention. And Lou said, you said you want to be supportive of your faculty, but I would almost guarantee you, as you're trying to be supportive, if you saw some educator being abusive, you'd want to take some action, right? And so that's really gets to Beth's point, which is, we might be very limited in our ability to do so, which would be extremely saddening.
Thank you both, and no worries, Jay. We love dogs here, so thanks for having him make a little cameo. Thank you, Lou, for your question. I just wanted to ask one more question. We have about 10 minutes remaining, so I'm going to leave the floor open after this one. This question was regarding acceptable use policies, technology user agreement policies, and potential misuse by students to either bully others or just in general misuse of technology. Maybe they've discovered Zoom bombing and something they're getting into. What can be done? What policies can be enforced by schools at this time, being the computer is primarily the way the student is accessing their education?
Right. So I think what you're going to want to be looking at is sorry, I don't have my ringer on. Now I have my own interference. You want to be looking at your acceptable use policy as well as your code of conduct in tandem. Usually the code of conduct will incorporate the rules of the acceptable use policy and make clear that students' failure to abide by the acceptable use policy may lead to student discipline and may also lead to the suspension of technology rights. Here, I am a little bit trepidatious about the complete suspension of those rights, given that in the school environment, there are other ways that students can still learn. There are decisions of the commissioner that have held, for example, that transportation, while it's normally a privilege, when it is tantamount to the student's inability to attend school because a parent doesn't drive or the parent doesn't have an alternate means to get the student to school, it's essentially a suspension from school because the student can't get there. And then by transportation suspension, you are in fact suspending the student from school. And I think we have the analogy here: when you suspend the student's technology, you are in effect during this window of COVID instructional time, suspending the student's ability to attend school. That said, although that is a concern I have, I think the way in which you address that concern from a legal standpoint or from a protection of your staff standpoint is to either follow the procedures of 3214 of the education law for teacher removal, where a teacher can shut the student down during instruction by following the removal from class procedure under the code of conduct. You would see it there. It is usually explained in great detail. It's pretty onerous. The teacher's, doing a private explanation of what it is that the student did wrong, and then excluding the student from the instruction thereafter with a follow-up possibility of written notice to the parent and conference with the principal, and then a final determination by the principal. And I'm oversimplifying it, but that's it. It's hard to imagine that playing out well in the digital contemporaneous platform. But where you have recorded instructions or email that's being abused, I could see it working a little better. If you're going to consider a flat-out suspension of technology that would no longer enable the student to participate in distance learning by virtue of them being cut off, for example, from the district server, then I think you have what you had in the technology example, the transportation example I gave you. I think you have a taking of what would otherwise be a privilege that is, in this context, tantamount to a suspension from school, which is still possible, but only by following the procedures of 3214 for either a short-term suspension or a long-term suspension. That would be my advice. but you should also, speak to your individual district council about that, because that's an opinion and not yet something that has been addressed definitively.
Hey, I just want to add one thing, and that is that these are great questions, and usually an attorney, one as great as Beth, will say, okay, here's the deal. This particular question's been answered by the commissioner on X and Y and Z time period, or our courts have said X, Y, and Z. And we look at those decisions to kind of guide us as to how we would answer an ongoing question. But you don't have to be a school attorney to figure out the following, that we are in totally uncharted waters. Many of the questions today are ones that are, they're almost sci-fi questions, right? Things that we wouldn't even thought about years ago. And I think what's going to happen is Beth and attorneys who are as gifted as her, and she knows I'm not buttering her up because I think she's wonderful, will give the best advice they can based upon how previous decisions in a school context were decided. And maybe that is exactly how the commissioner will rule, or how a court will rule. Or maybe they'll say, no, we think the rules are different now because people are home and we have to give more flexibility. So you'll have to ask those questions of your school lawyer. But I think school lawyers are going to be in this very weird kind of place, because it's not that they're going to make up the answers. They're going to give you answers that are the best answers with what we've gotten, even though we don't have any case law upon which we can build this, because this has never happened before. So I want to share that, not to cover for school lawyers, but to say, it's not like the old days where the great school lawyer would be a person. I always joke with Beth, because David Shaw, who is the senior partner of her firm, he not only remembers every single case that's ever been decided, but he knows what page number it is in the different legal volumes, and he astounds all of us by his encyclopedic knowledge. But my point is, even that won't help, because there won't be cases that have been written this way. So stay tuned for a very rocky road ahead as things get litigated.
Yeah, I would say in the spirit of Kenny Rogers, whose death happened shortly ago, we're being forced to deal with, playing a bad hand well, like knowing what to pull, knowing what to keep, and how to play those cards that we've been dealt now, collaboratively, and figuring these things out while we're flying the plane in the air, we're building it. So.
Yeah.
Sorry, I was muted. Thank you both. Thank you so much for your time today. We're coming upon just about 5 minutes left to the hour, and we're transitioning to a next learning session at 3 o'clock. But it was really such a pleasure to have both of you today. Thank you for your thoughtful answers. Thank you for your guidance, your support, and the things that you've shared. I know that like all of my colleagues here, we are in very uncertain times. And I appreciate you lending the expertise and the insights you do have to us as we kind of muddle through what this looks like now. So thank you. Thank you, Jay, for joining us last minute.
Pleasure.
Beth, thank you.
Pleasure.
Still looking forward to having
to be with you.
Podcast with you. And everyone look forward to seeing Beth again real soon. I have a podcast called Making Meaning, and I'm going to interview her on it next. So I'm very excited about that. We're going to plan that date soon, one day when she can come out from under all of the calls and requests. But
everyone, I hope everyone stays healthy, and thanks for the opportunity to talk with you all and spend the hour with you.
And I want to say the same thing, that in closing here, all of these questions are important, but the most important thing is keeping yourselves healthy and your families. And these are very trying times. And the fact that you all are able to keep at least a good portion of your attention on your work, I praise you for that. It's an amazing thing that you're doing, and thank you for doing it.
Thank you for saying that, Jay. Our leaders are doing so much, and we value them so much. They're wonderful, courageous, great people who work very hard. So thank you. And thank you both. Thank you, everyone, for joining us. For those of you joining me for the Middle School Principal Roundtable next, I'm just going to close out of the meeting and then come back in so that the recording stops. Have a great day, everyone.
Thanks,
Bye
Jay.
now.
Take care, everyone.